Good morning, good afternoon, or good evening, wherever you are. On behalf of Teaching International Law Interest Group of the American Society of International Law, it is my pleasure to invite you and welcome you to this webinar. We have an exciting panel of colleagues today. We have Megan Donaldson from University College London. We have Roxana Banu from Queen Mary University London, and we have Wilson Louis from University of Hong Kong. Before I formally start the webinar by putting some questions, please allow me a minute or so to give the context to this webinar. Teaching public and private international law is something that often transcends many sort of silos, and we often teach it from different perspective. We teach it with different context. We teach it with different pedagogical practices. And we also wonder that what do our students do with our teaching? What do they do with the law of the teaching that we impart in our classrooms? And it is perhaps also a field where, as one colleague has already put it, that beset by this Austinian question of law, how do we treat international law or teach international law to students who may not be in the leading law schools, who may not have the economic or social background to pursue public or private international law in one of the leading law schools? So the colleagues who are here with us today will explore these questions. So before we delve into the other questions, let me start with the context. So I first invite Roxana to give some context to teaching public and private international law. Roxana, over to you.
Great. Thank you so much. Thank you, Rizwan. And just a quick thank you to Megan, who brought us all together today to talk about this. And it's really such a treat to talk amongst colleagues and friends about how we teach the subject that we love. So I'm very grateful for the opportunity. So my name is Roxana Banu. I'm a private international law scholar. And I guess I'll start by saying a few words about myself and my trajectory into the field of private international law to explain how I come to reckon with questions about teaching the field. In a way, teaching is such a personal experience anyway, so we need to get a bit of a background about who we are first before we talk about what we're trying to identify about ourselves in teaching the field. So it so happens that for many different reasons, I've jumped through a lot of different institutions and moved geographically quite a bit. So I've had the privilege to teach private international law at Fordham Law School in New York, at Osgoode Hall in Toronto, Canada, and then at Western Ontario in London, Ontario. And I moved to the UK 3 years ago, but haven't had the chance to teach it yet. So I'll start teaching private international law, in fact, at Oxford University, where I'll be moving to in September for the first time in the UK. And I should say I was trained in private international law in neither of these places that I'm teaching it in currently, but rather in Germany. So I suppose at this sort of juncture where I'm moving again to another institution, I wanted to grapple a little bit with what I've learned from teaching it in these different places and what I've learned from being taught the field in Germany and sort of what I think about teaching the field going forward. So this is the context in which I published recently an article in a special edition that both Megan and I contributed to, a special issue in the International Journal of Law and Context about teaching private international law historically. This was my contribution. And the argument I was trying to make in the article, and we'll talk about it, I guess, in different bits and pieces as we go along, is that I think we might try to understand how to think about teaching private international law a little bit differently. Now, my view is that there are generally sort of three ways in which we tend to teach the field. One is a very technical, very doctrinal perspective on private international law, which focuses very much on its techniques and on its doctrinal vocabulary and less on its principles and its modes of rationing and rationalizing what it's actually doing. This is, I suppose, the type of teaching private international law that allows students to go very deep into the field, but is also a relatively off-putting type of engaging with the field sometimes. And I should say it's also the kind of teaching of private international law that encourages a mirage that it's very, very different from public international law. Maybe we'll talk about that as we go along. Another type of teaching private international law is a more substantive way of engaging with the field, but highly critical, and then critiques really quickly. A way of jumping from private international into social theory very, very quickly, and describing how the field, through its vocabulary, might actually mask power, how it fails to translate lived experiences of individuals in the transnational context, and so on. And the third version of teaching the field is almost the opposite of this, the second one, which is a highly idealistic view of the field, where we tend to pick on what's wonderful about private international law, the fact that it tries really hard to grapple with connections between different legal systems, positioning itself amongst different sets of values and sort of normative views about the law in the world. And so we're trying to idealize it. And I guess one thing I wanted to try and think about is whether there is a way of teaching private international law that combines the best of these three perspectives. One that allows students to dive really deep into the field, so not a shallow critique that jumps out of the field really quickly, but at the same time, one which shows both the sort of empowering functions of private international law as well as the potentially disempowering functions of the field. So how could we engage with the field deeply, take it seriously, but at the same time be mindful of exposing students to both sides of the field operating in the real world? So this is my entry point to teaching by historicizing private international law. Okay, I'm gonna, who's following me along? I guess I'm stopping here and then I'll dive into the details of this a little bit more. Wilson, I suppose you might wanna jump off of this. Perfect.
Yeah, sure. Yeah, thank you. And thank you, Megan, and thank you, Roxana, for inviting me to this panel. I'm Wilson. I'm a part-time lecturer at the University of Hong Kong. I taught private international law as my main course. I'm sole convener of it. And I designed it as a new course because it has been not offered for like 8 or 10 years before it's again offered, which is surprising, I mean, for a law school in Hong Kong. So when I first approached the question of context, I think it's important to situate perhaps in terms of geographical locations, because Hong Kong, of course, has a close connection with mainland China. And in fact, we do have quite a lot of students, postgraduate students from the mainland China, very much hoping to learn the common law or the ways of thinking about law in Hong Kong. So it's interesting here that first, there's a very stark contrast between the legal traditions that the students come from, because there is a difference in the common law tradition versus the civil law system of doing things. So one difficulty perhaps that I immediately can highlight is where some students cannot understand or find it difficult to understand common law concepts, while some of the Hong Kong students find it difficult to understand previously well-known concepts as applied in the wider international law world. So it's interesting to see how students have struggled with this kind of view. So that's one kind of context that I want to highlight. And of course, when we teach about the subject, when we go into content, there are also other kinds of context. So another kind of context I'm thinking of is linguistic context, where obviously there are also a lot of Chinese cases or Asian cases where you have to deal with another culture or another legal system, and there will often be, in private international law, we have conflicting judgments coming from different places. So it's interesting to see how issues with the Chinese language or different languages could cause misunderstanding and sometimes disputes in the other place. And so it's also a challenge in a sense, and probably the course, if I have to teach one, which I did, is struggling between these kind of contexts. But it's also interesting to see how the course can be engaging with these kind of contexts. So perhaps I can discuss more in the later part, but maybe Megan can also introduce some kind of background before we go on.
Yeah, lovely. it's a pleasure to be here and to be discussing with two wonderful private international law scholars. Just before I say something about myself, I want to acknowledge that a couple of our other panelists, Ananda Bora and Mohsen Alata, have not been able to join us today due to emergencies that they're facing. And I feel their presence greatly. Ananda had recently initiated a kind of international law program at a university in India and was going to speak to that experience. And Mohsen Alata has taught public international law in, I think, more than 10 jurisdictions. And he and I have recently been co-teaching public international law. So I encourage everyone to take a look at his writings on this theme online as well. So as for me, I did my undergraduate work at the University of Melbourne in Australia, and then I did a master's and I did a doctorate at New York University, which is, you know, an American law school, but the doctoral program is heavily international. And I then came to the UK. So I have taught survey international law at the University of Utah in the US, and I've contributed a bit to teaching at Cambridge, but most recently at University College London. And that's really the place from which I've been coming when I was invited to think about teaching international law in context by the International Journal of Law in Context. So I think it's tempting when we want to talk about teaching in context to be highly aspirational. And I am going to speak about an LLM module, which is highly aspirational, that wants to kind of begin teaching quite differently, work differently with historical context, foreground concepts of peace, and problematize the way law and history might construct those. But I think it's also really important that we think about these questions in the context of our survey teaching, where, you know, context can be somewhat more difficult to navigate. It tends to be highly institutionalized, tends to be highly collaborative, this teaching. It has to be stable over time. So it can be quite challenging to think about the choices that we're making pedagogically and kind of not be in a rhythm of just reproducing what we have always reproduced. I also wanted to say just a little something about the context from the student side, which I think is really important. So in teaching an international law survey, I've registered among students obviously a huge spectrum of experiences of the world. Many of the students have been on the hard end of conflict or of the experience of being a refugee or an asylum seeker. They might be at the other end of the spectrum from very privileged backgrounds, from a huge array of kind of geographic locations as well, coming to London to undertake their studies, as well as British students. And I think there's a diverse set of hopes and aspirations about the world that we have to grapple with, but also some pessimism and despair at the moment, particularly in the context of climate change, the frustration of electoral politics in many of the jurisdictions that these students are coming from. And that really does influence the hopes that they bring to international law, but also the way that they look at the module. So teaching in context is also dealing with students who are in complex contexts of their own. Roxana, do you want to pick up with your further thoughts?
Sure. So I guess perhaps I wanted to say a little bit about how I'm thinking about teaching in context, as I was saying earlier, in a way that capitalizes on what's good and what's bad of the field. So to pick up on something that you just ended with, students coming into public international law, they sort of grapple with the field in a contextual way already, because it's much easier for them to understand how the field operates within broader geopolitical contexts. But students coming to private international law do not. So students coming to private international law often perceive it as a very useful course that will help them become practitioners in transnational litigation, for example. And so the initial challenge is to try to teach the course in a way that doesn't minimize their interest or their focus in that way of seeing the field, because of course the field is actually really practical and incredibly lucrative as well. But to at the same time expose them to the geopolitical context in which private international operates, which is not as obvious when you dive into the field. So in a sense, private international law students coming to private international law do not inject any kind of pessimism, despair, or any kind of perspective on the geopolitical setting when they come into the field of private international law. They see it as a very, very deeply practical, commercial field. And so for me, I guess the challenge is almost the opposite of you, which is to re-inject an awareness of what's happening in the world and how private international law has something to say or to do about that. So for me, it would actually be wonderful to see students think about the field of private international law, even from a pessimistic note of despair about what's happening in the world. So the struggle is to think about teaching private international law in a way that brings that to the surface. They get to see that private international law actually operates in this global context and exacerbates crises that we already have, or might help alleviate some of the problems that we have. And in this sense, the historical context that I'm trying to inject is trying to bring private international law cases into historical context where private international law helped or didn't help, so that students can understand that its own techniques, its own value judgments are always doing some work, and it could be for the better or for the worse in different moments, depending on which actors use it.
Yes, can I just say I completely agree with the point that you just made, Roxana, on how students see private international as a practical subject, rather than coming and say, oh wow, I need to change the world by learning this, and I can do things with it. So I think it also is attributed to perhaps a lack of comparative law understanding or teaching in general. I can speak for Hong Kong. I don't know if it applies to other more developed Asian jurisdictions or so, but obviously there might be difficulty, or it isn't really incorporated into the curriculum about how our laws work, how our legal systems work, and there obviously a diversity of legal systems operating around, and private international law is of course all about potential conflicts, or when I go further, harmonization between these kind of legal systems. So again, I will start with the general legal topics, the direct jurisdiction, choice of law, all the things that you can think about on the practical side. But then moving forward, they have to also delve into a deeper discussion on how the values of international law are shaped through the domestic rules that are implemented into the respective jurisdiction, and how they are compared with the other jurisdictions around us, and eventually leading to a more nuanced or more comprehensive worldview towards different legal questions. And I say this because I'm recently also reading works on sustainable development goals and how it might relate to private international law. Obviously, I think there's an edited volume by Professor Ralph Michaels and others on this. So it's difficult perhaps now, but it's increasingly important to see the interconnections between international law and how we're going to move the world forward by looking at these sustainable development goals.
Thank you to all of you for your context. Now, if we move to the pedagogical questions, the practices, well, how do we teach international law to that enable students to do something with the law? Well, we may have some particular critical perspective. The students may come from critical perspective, but still they would want to achieve something from law. So how do we train our students to do something with law or against law or through law? So that's a question that maybe we would now explore. And as our panelists answer this question, I humbly request all attendees that the Q&A box is there. You may put in your questions and we will try to answer the questions put by you. So at this juncture, I would request maybe Wilson to start off, and then the others will jump in. Wilson, please.
Sure, yeah. Well, in terms of the actual pedagogical, well, I've just started actually on something about that very briefly. I started with, the usual 3 questions you ask disciplines that you ask in private international jurisdiction, choice of law, and recognition and enforcement. And the common law system, as you will know, takes a fairly settled approach towards these questions. Of course, there are controversies here and there but I mean, they're fairly well developed. Students just read the usual cases, they just read the usual materials, books, and then they get it. They get the principle, and then they just apply it in the exam. That's the usual way of thinking. Students think they read the materials and they get what they want for an exam. That's enough. But of course, there are interesting bits here and there, and it's important in the course to bring these up. For example, one kind of example I'm looking at is the proof of foreign law processes. So there's obviously a divergent approach between some systems, common law systems, proving or pleading by expert evidence. We need experts coming in to say the content of foreign law in the particular jurisdiction X. But in some civil law jurisdictions, they tend to make the process by ascertaining them through the court. So there will be agencies responsible for ascertaining the contents of the foreign law for the courts and the parties, and then the dispute will be decided according to that ascertained foreign law. So, and it's important for students to look at these changes or developments, like if in the UK Supreme Court recently, the Brown HU case, we have a relaxed approach towards the proof of foreign law. So it's interesting. Students have to see that even in the common law system, things are changing, and it's important to see these changes through a more open view towards these kind of questions. So we have sessions arranged around these topics. We are asking students to specifically talk about these and think about these, and how does it relate to the larger question. So to me, there's an additional question here, the higher layer on perhaps harmonizing, but also on how do we reconcile the different views towards the same legal question. And that perhaps that's one thing I would start with before maybe responding to others.
Roxana, I feel like private international lawyers should speak in conjunction.
Yes. Right. Okay. So perhaps I'll give a very concrete example, which I try to sketch in this article on teaching by historicizing, just to give a little bit of a sense of how it would concretely work to teach by historicizing private international law. So I said earlier that it's very important to me for students to engage deeply with the field before critiquing. It's important to me that they understand what the field is trying to do in different moments for different purposes before applying any kind of critical lens on the field. So I will take, for example, in a section of the course on choice of law rule in tort, we will start with the current rules of tort law that say you on a transnational tort matter, you apply the law of the place of the tort. And I start by talking to the students about the general way in which we understand the current law. And it's often described as wonderfully cosmopolitan, because the place of the tort can be anyone, not necessarily the law of the forum. So we don't have any preference for the law of the forum. We are engaging with a field that is mindful of legal pluralism and encouraging diversity and managing it in the best way it can, but generally neutral way. And so I start with the current law and then dive into the historical context. And from the current law, I go back in time to the late 1860s. And I talk to the students about where tort rules in the common law traditions sort of jumped off from. And that is not your ordinary tort case of the usual cross-border car accidents that we would imagine, but in fact, a colonial case, a case that dealt with the prosecution of the governor of Jamaica for the violent repression of the Moran Bay rebellion against British colonial rule in Jamaica. And in that case, the question was, do we apply the law of England, which wouldn't have allowed for this kind of action and would have allowed for a tortious recovery against the governor of Jamaica, or do we apply an indemnity rule, which the governor had passed to shield himself and others from responsibility for violently repressing the rebellion? And it turns out in this case, the court tries to rationalize what to even think of Jamaica as a jurisdiction. Is Jamaica a foreign country? Is Jamaica an extension of England? And this becomes a core question for private international to even understand which law to apply. The background assumption is private international only operates when a foreign jurisdiction is involved. And so the court ends up arguing that one had to apply the indemnity rule because Jamaica was a foreign country. England owed Jamaica comity to recognize the indemnity rule that was passed precisely by the colonial government to shield himself from responsibility. And so I sort of turned the framework around and I asked students, well, if we now think that applying the law of the place of the tort in a neutral manner is a cosmopolitan way of thinking about it, well, imagine this scenario in which the same cosmopolitan language was used to shield colonial governors from responsibility for a violently repressing a rebellion by constructing different parts of the empire as akin to foreign countries in relationship to England. And so then we dive into a discussion about what does it mean for private international law to even understand a foreign jurisdiction as foreign? And can you understand a foreign jurisdiction as foreign in different contexts? The colonial context being one, then I dive into the interwar context where social workers were trying to grapple, for example, with how to understand tort remedies for cross-border desertion of women in the interwar context, where families were scattered across borders, both in Europe and on both sides of the Atlantic. And then the question was, how do you localize the tort of desertion? Is it localized in the United States, where the husband happens to reside, but the wife is back in Europe? Is it localized in Europe? Is it a European problem? Is that a jurisdiction that is separate from the American one because the tort of desertion sort of became disconnected in the process of post-war relief programs and so many other? And then I jumped to some wonderful speeches that were made by private international law scholars, sometimes before highly reputable international bodies or international organizations like the Grotian Society of International Law, where you have an entirely different historical lens. Private international scholars portray precisely tort rules of private international law as a human rights law vocabulary, so says Ben Atkinson Wordley, for example, a human rights law vocabulary that was there all along in private international law by the time public international law wakes up to the issue in the post-World War II era. And then I asked students, well, how can that be? Is this a version of private international law that we recognize in these examples prior to the Second World War? Is this a version that we can tap back into? Is this something that is lost from the tradition of private international law? Where exactly are the human rights dimensions of private international law in terms of the tort rules? And so then we expose a whole range of context about tort rules, so that by the time we come back to contemporary law, we can now understand that there's potential in tort choice of law rules. Perhaps they could have a human rights law-like dimension, but there's also a danger in choice of law rules of operationalizing a sort of humanistic and cosmopolitan language to hide abuses of power. And then students can sort of take that as baggage and trying to understand what they think about the field and the way it operates in the world in different contexts. So I'll stop there. Megan, you carry us forwards to the public international law scene.
So, I mean, I'm deeply sympathetic to much that's just come out of Wilson's intervention and your intervention. And the three themes that I would pick out, this question of engagement before critique. So equipping students to understand a field in a way that can root a sort of original articulation of critique rather than sort of a repetition of points from others. Secondly, that this value of history, right, as if not a kind of locus from which to think, then at least a language or an approach through which we can get our hands on difference and change and possibility. And third, I'm just so struck when you're speaking about private international law as managing pluralism and diversity, and this historical approach problematizing what's inside and outside, what is a foreign jurisdiction. This is all the stuff that's going on kind of under the carpet, as it were, in public international law, because I guess in kind of common law Anglophone teaching of public international law, there's a canonical question. Do you start with statehood or with sources, right? And if you start with statehood, then you are obviously at least taking as a basic premise the division of the world into states, which, you know, as we know, is quite a recent and contingent phenomenon, and hiding all of this complexity of the colonial background. And if one starts with sources, then one is almost presupposing a kind of ordered normative system, which doesn't really account for the messiness of how states have emerged as political entities. So all of that kind of complexity of political interrelationship is sort of absent, I would say, from a standard public international law survey. We get to it in a topic which is sometimes in the UK called international law and English law. And that in itself betrays a complexity, because we're talking about the legal system of England and Wales, not Scots law, not Northern Ireland. So, you know, there's an enormous amount of richness that we could bring out if we brought private and public together. But let me say something about public international law now. So I said before, I wanted to speak to the survey course as well as to kind of a bit more freewheeling master's module. So in the survey course on public international law, which I'm teaching at the moment with a number of colleagues, I think our strategies for contextualization have taken a few forms. I think there's been a running theme of thinking about international law from a British perspective, not because that's a kind of canonical authoritative perspective, but because that's the place in which we are located. And whether students are UK nationals or whether they came to this country, they have a particular understanding of, you know, Britain's place in the world. And I think that in a sense, leaning into that helps them to unpick some of these questions about universality. It doesn't teach them that, you know, British international law is particularly authoritative as a way of approaching things necessarily, but you know, with decisions like the Chagos Islands case on self-determination, with the UK's ongoing issues with asylum seekers and its difficulties with multinational human rights conventions and so on, there is a great deal of particular material to bring to students and have them work through. So I guess one contextualization strategy, an obvious one, would be start with the place where we are, knowing that that's not the only place, it's not the central place, but it's a place where we can have a fruitful conversation. We've also tried to think a bit about the texture of public international law. And this I think will be familiar to anyone who teaches public international law survey courses. There are certain foundational pillars, right? Sources, law of treaties, law of state responsibility. And there are institutional frameworks for peaceful settlement, but how those all come together in different areas of law varies quite a bit with what area of public international law we're talking about. Are we talking about human rights? Are we talking about economic law, trade and investment, and so on? So I really encourage students to move between the different layers, the general and the particular norms of the area of law we're talking about. And in a sense, to situate each of those interfaces, right, between, for example, last year we taught human rights and international economic law together, to begin obviously from the kind of basic norms that public international law has for thinking about regime interaction, but then move down to the level of detail and really think about how those concerns pan out in particular institutional sites, particular decisions. My more freewheeling master's module takes a slightly different approach, and that's a historicization approach, I guess, akin to Roxana's. So I'm looking at history of international law through the theme of peacemaking, and I'm trying to put peace and law and history in a sort of triangle to read each of those contexts or disciplines against each other, and to deliberately unsettle the way students read. So we begin with peacemaking between the British monarch and the Cherokee Indians in North America, and we look at a range of different sources, the way that Native American groups organize themselves politically, how that then gets registered in a transcript of the interaction between their representatives and British officials, and how that then gets rendered in turn into a treaty. So I'm deliberately trying to decenter the way that people might come to what they would canonically think of as law, but that's a category we might want to revisit.
Thank you for the answer. Now, any other reflections on pedagogical strategies that we may not have yet covered? From any one of you, please.
Can I just come? I'd really like to hear more from Wilson about this harmonization idea. So how do you position your teaching of private international law in this context of a larger project on harmonization, and how does that shape what students take from your course?
Right. Yeah, it's perhaps I have to go back to how the course is situated, because unlike survey courses and topical courses, we don't really have a course separate from each other. So we only have one course for both undergraduates and postgraduates, for exchange students and for Audi. So it becomes a bit of a mix of student population, of course, coming from a diversity of backgrounds. So I haven't really had the chance to incorporate all the interesting perspectives that both of you have just mentioned, and perhaps it might be a bit difficult. In terms of harmonization, I think I usually start with the Hague Conference on private international law, because that, to me, is the whole institution is working towards the progressive unification of private international law. Conventions, hard law instruments coming out saying, well, if you contracted to this particular convention, you will follow a certain rules towards a certain particular topic. But then recently, of course, there are criticisms towards how the Hague Conference is working. And of course, there are other kinds of instruments, soft law instruments or non-binding guides instruments that could help states in coming into a cooperative attitude towards certain kinds of topics. So I think the harmonization question permeates, of course, throughout all these questions. And again, I think the challenge for Hong Kong students is to break through the usual common law thinking and to have a broader understanding of these issues. So, of course, they have to read more broadly, of course, in terms of other kinds of materials. But then, starting from the Hague Conference, I take up in conventions instruments for them to see how it might have to be improved, or how that might not be applicable, or you have to ask why are states reluctant to enter into certain conventions, for example, the more recent 2019 Judgments Convention. So through these questions, they ask about their own legal systems and also about other legal systems on how they deal with certain questions. One question perhaps I can think of is family law, because that is obviously a big question that is that has a different cultural or social or historical considerations. So in some jurisdictions, obviously, religious issues, marriages, divorces will be a concern. Some jurisdictions might have a different view towards families. Of course, in Chinese, we have the customary Chinese law, which still have certain effect in Hong Kong. So students have to think about how the regime could be improved to encompass or to recognize more different kinds of marriages, including same-sex marriages, which is currently under challenge again in Hong Kong on how do we recognize foreign same-sex marriages. So this will be a context that they can start with, and then they move on to consider the harmonization progress by looking at the rules in different places and how they could be kind of reconciled in different ways. So that's the whole point. And of course, there's also recently talk about Asian private international law as opposed to the EU or Western side of thinking. So it will be interesting to see, is there really a kind of Asian private international law? How do we define Asia as a region first? The most important question, and then if there is anything in it, what we mean by Asian private international law. It seems in the sense we don't have that kind of diversity. We have a lot of diversity in Asia, as opposed to a more regionally economically integrated region in the Europe. But we also have different ideas, languages, cultures, histories that we have to reconcile in the Asia region, which makes it a particularly difficult region to talk about private international law, because there are certainly conflicting regimes indeed. Yeah.
It's really interesting because sorry, Roxana, go ahead.
No, go ahead. I wanted to transfer to another point, so you go ahead.
So, well, this might take us in another direction, but we can come back. One of the questions that Mohsen and I were throwing around together when we thought about this panel was the idea of innovation. And what are we doing when we're teaching law? Are we just teaching what the law is, or are we teaching how it changes? And, you know, in public international law, one can do that in a few ways. One can work on showing students, right, how a treaty is negotiated, how soft law is generated, which is a subtle, very sociological process. Or one can talk about kind of conceptual innovation, which in a way comes from elsewhere and is brought in. So a concept like the common heritage of mankind, or as kind of B.S. Chimney has noted, that the massive innovation that is investor-state dispute settlement, right? That kind of was brought into the law, it was actualized, given shape by law, but the thinking isn't necessarily uniquely legal behind that. It comes from other disciplines as well. And so this challenge of teaching students how law changes and how they might do things with law, it's obviously very difficult in particular, constraints of a syllabus. But it struck me that harmonization was a kind of a way that law changes, but it's obviously not one which is on the public international lawyer's radar nearly as much as is the case for private international law. It's a very distinct way of thinking about innovation and how things change and where the center of gravity moves to. Something that really interested me in the intersection.
Thank you. Roxana, you wanted to say something?
Yeah, just a quick point. So Megan was talking about how in public international law, one potential debate to have with yourself, even as a teacher, is whether to start with states or institutions. And one thing I wanted to say is that this is actually a very good entry point for thinking about how one might contextualize public or private international by reference to each other. So one way of contextualizing public international is by bringing it in conversation with private international and the other way around. And one particular useful entry point is precisely this question of what is a state? Because, for example, while different parts of the British Empire were never recognized as states in a public international law, they were often, almost always in private international cases, understood as akin to foreign states in relationship to each other and to the metropole. Now, that's a very different way of thinking about statehood in private international as opposed to public international law. Long before, while the League of Nations and different governments were grappling with whether or not to recognize Soviet Russia, private international law scholars were trying to understand how to recognize it as a legal system nevertheless, because recognition was just not an option in private international law. Cross-border interpersonal relations were continuing. And you couldn't just say, well, we have nothing to go by. We still have to apply some law to these cross-border interpersonal disputes. And so one might recognize certain legal system in Russia without recognizing the Soviet regime as a state. And so there's so many different parallels that we can bring in conversation on the private international and the public international law side. And if we did, I think we would end up contextualizing each field by reference to each other. So that's another kind of innovating how we contextualize our own fields by bringing it in conversation with the other field, where that historically was actually linked to. Historically, the two were linked to each other. So by bringing that back, we might actually get more purchase power for contextualizing of both fields.
Yeah, the question of state is certainly interesting. I mean, and going back to Hong Kong, that's the first thing you have to say to people, that Hong Kong is a state in the private international law sense, and that state stems to a whole lot of questions on how you have to interregionally cooperate between the mainland and Hong Kong, because all kinds of arrangements do not apply within the same sovereign state, but also within jurisdictions. Yeah.
I just see a note.
Yeah, Megan, please go ahead.
So I was going to interpret your note, Rizwan, that we have some questions from the audience. So maybe what we should actually do is take a couple of the questions and react to those rather than continuing necessarily with our plan, and we can weave in any other points that we'd like to make into the Q&A perhaps.
Thank you. So first question is from Gail Litko. I hope I have pronounced her name correctly. He has three questions. The first question is, do you ever situate private international law for public international law students and public international law to private international students? How do you do this? What does this do to how we reproduce this schism between the two disciplines? So who would like to answer, please?
Well, I think it's certainly interesting. I haven't really done that, but in a sense, and I'm not trained in public international law in that way, but it's interesting to see, for example, when you introduce the concept of state immunity to students, of course, it applies in the public international law sense to different things, but you have to go through how it also might apply, or it might also affect private parties. And that's interesting, because if you separate public and private international law, it will cause us to ignore the realities on how international law actually also affects our private lives, and how does it how does the global economy work, in a sense. So for example, in recent cases like how immunities might be brought as a defense to, for example, state-owned enterprises, or how things that might be out of control, it's interesting to see how these are integrated. I really just put a brief note for now, but perhaps in the later time, when I have more time to consider the interactions between these, it might worth some time for students to know also about these intricacies.
I hesitate to
Any
say
other
something
colleague
because
would like
I
to
could
go?
go on forever.
Roxana,
So,
Yeah,
so
please,
I
go ahead.
hesitate to say anything because I could go on forever on this topic. So maybe just briefly, you know, I've written on the history of the alignment of the two fields. And so one way in which I often bring it to the students is to say there is an entire history of the alignment of the two fields. I mean, that in itself is a whole topic. So I try to ask students to distinguish between a number of different ways of intersecting fields. One is a philosophical alignment between private and public international law. At the time when private international law was forming as a field, the big debate was, should we think of private international law like public international law? Is it doing the same thing? Is it part of public international law? Are they together part of a broader range of international law topics? And that's a history about almost the origins of private international, if you will. And that's one debate. The second debate is, do you have cases or particular cases in private international law that are both private and public international law? That's another avenue which I often pursue. And so for me, for example, the Chagos Islands case is both. And it's best illuminated when you look at it from both perspectives. And then we have, so that's one that, you know, the history of private international law via public international law, cases that align with both. And then sort of a contemporary conversation that is still happening in private international law about all kinds of core topics of private international law, like the concept of statehood, that have always been and will always continue to be topics of both fields. And then the idea is, could you look at them in a class, even on private international law, by showing how public international law deals with the same topic, the same doctrine, or the same concept? And ideally, you would do a bit of both, but it's impossible. Oxford has a couple of seminars that they dedicate to pressing issues that they want to explore about private international law in general, which is wonderful. And oftentimes the alignment of private and public international law has been one such topic. And that's an ideal way of doing it because, of course, you dedicate at least one seminar to making students aware of this alignment from multiple angles. Myself, I usually include it under different topics. So when I discuss tort, when I discuss the concept of the state or legal system, or when I discuss the history of private international law, I'll dive into public international law.
So I don't know that I have a perfect way of situating in either direction, and certainly not as comprehensive as Roxana's. But I guess what I do is take the outset of public international law as a moment to say that students are stepping outside a legal system which is most familiar to them. So it is a moment where that they are having to think differently about law. And I would try in that context to speak about the way the intersection of international law and domestic law divides certain issues or channels some disputes into one place and not another. And I would in that context say something about conflict of laws. And it does sometimes induce surprise. So I'll say, so those of you who are studying conflicts, and there's a kind of moment of surprise that I'm connecting these two things. And I say, look, you know, let's think about what we consider public and what we consider private, and what ends up getting sorted into what legal system and what institution. And so that, in a sense, is a minimalist situation, but it at least leaves it that there's a question there. And Gail, just because I'm intrigued by your questions 2 and 3, I'm going to say something about those as well. I think this idea of blending doctrinal and critical is kind of a central challenge for a lot of us. because students need to understand enough that their critique can come to grips with the complexity of the subject. But at the same time, you don't just want to do 19 seminars on law as it is, and then you get to have a little discussion in seminar 20 about the critique. So I guess my workaround is to kind of articulate where the norms came from, what the conventional view of the norms is, and then ask students to say what they think the effect of those norms might be, broadly speaking, in a distributive context. So I do start typically with some kind of historicization of the interstate order and of what we would call international law. So they have a sense that things were not always, treaties and custom. And that seems to be enough of a basis that they can begin to kind of posit theories, right, about the distributive consequences or the implications of the way the norms are now. So I guess I wouldn't say I'm teaching doctrine and critique at the same time, but I'm trying to teach doctrine in a way that's open to critique. And you had a fascinating third question, but I think it's disappeared from the chat. So hang on, let me just see if it's opportunistically been labeled answered, but experiential learning techniques. I would love to do more of this. This is exactly the question that I had in mind when I was thinking about teaching students how to do things with law. It's just time consuming because they have to understand enough about the individual genre of treaty drafting, for example, at least read some biographies of, third world scholars who are trying to craft a new international economic order to understand those struggles, talk to people involved in the climate change regime about the way some of those agreements are structured. And that's just one genre. That's a genre of kind of treaty making or agreement making, soft law making. If I could figure out a way to do that experiential learning within the framework of the syllabus, I'd be very happy. I would love to do more of that experimentation.
Thank you, Megan, for those answers. In case either Wilson or Roxana wants to answer the second and third question, let me put that again. The second question was, have you ever tried to blend doctrinal and critical approaches in your teaching? So every class is always both. How do you manage this? And the third question, as Megan has already answered, that in terms of pedagogy, how useful do you find experiential learning techniques in each of your class? So if Wilson or Roxana would like to add anything, you're welcome.
I mean, I can be brief on the third one, which is easier for private international than for public international law. So, for example, bringing students to a Supreme Court hearing on a major private international law case is something that I've done in the past, and it's extremely helpful. The other thing that I would like to do and haven't done is to have students learn private international law in this historical mode by looking at original documents. So, for example, if I teach them the origins of the choice of law rules, I would like them to read some of the correspondence between London and the governor in Jamaica about how they conceptualize Jamaica as a state. Right? It's a very interesting counterpost to how it comes out in the judgment. But I haven't done enough of that. The dilemma that you pose in your second question is, of course, the perennial dilemma. I guess this is the starting point for all of us. How much doctrine do you do before you actually engage in critique? And it's a very difficult exercise. Like I said before, for me, it's very important that students understand as much of the law, of what the law is trying to do as possible before they engage in critique. I think there's a real danger in rushed critique, in superficial critique. So I try to do quite a bit of doctrinal background before we engage in a critical approach. Ideally, I would like to do it in every class because I think that there's something very powerful about not having it as an afterthought at the end of the course, but actually having each concept run through a critical lens. But it depends very much on how hard the doctrinal background is for the students to grapple with. And like I said, I don't want to jeopardize that kind of crafting of the understanding of what the law is trying to do before we jump into the critique.
Yeah, just very briefly, I think I'll just ask questions along the way when I introduce certain topics, and maybe asking perhaps, is it the right way to do it, like right now, or is it do we have other ways of doing the same thing? Perhaps that's how I blend a little bit of critical perspectives, but it's difficult for students who are so eager to learn just the practical stuff and then just trying to get hold of it for their future career. So in Hong Kong, perhaps that's not quite possible yet. Experiential learning, again, I think the ones that I mentioned are quite good. Of course, I also invite students to talk with other people, attend seminars or whatever. They also learn other things or things that they do not understand through these things, and then they'll come back and ask. And that's also one way of thinking about experiential learning in international law, which is very pluralistic and diverse field with a lot of events that they could do. Yeah.
Thank you. The next question is from Fatima Mahmood. She asks, in teaching international law in contexts, how much room is there for students to reimagine existing paradigms? Specifically, how does a more representative intellectual inquiry into historical context induce radical reimaginations? Thank you.
So I think this is going to be actually a fantastic question for us to end on, just because I think Fatima's final question also in the chat connects with the doctrine critique line that we've already explored. But for me, the idea that teaching the history differently opens up new possibilities and paradigms is kind of fundamental. Like, that's one main reason for me to do that historical work. And I think on even the most basic level, it's important when we teach to highlight where there are these moments of innovation, which seem kind of pat to us today. So human rights, right? Standard individualist liberal human rights, as critical as we might be of that as a framework today, was a fairly significant innovation, and the whole institutional apparatus around that. International criminal law, another area in which I teach, involves pretty fundamental innovations in kind of a triangulation of institutions and doctrine and values, all of that articulating together. And then, as I said, things like investor-state dispute settlement, that's a pretty fundamental and disruptive innovation, right? So even just highlighting where these moments of innovation come, and where there are moments of attempted innovation which are not carried through. So I guess that would be aspects of the NIEO kind of moment in public international law. I think emphasizing those is at least an entry point to thinking about how we might reimagine different paradigms. And in my master's module about history of international law and peace, I may have gone too far in the other direction, because we came out the other end having very little faith in peace as a concept at all, or in specifically legal constructions of peace. So I think we deconstructed that quite thoroughly, and I look forward to picking up those reflections next year.
Any answer from Roxana or Wilson? Would you like to add anything?
So, I mean, this is, I would agree, first of all, with Megan entirely about the fact that doing history differently and carefully is just one avenue in which the questions unravel rather naturally. You cannot avoid the context, you cannot avoid the dilemma, you cannot avoid the contingency, and therefore students would have a very hard time trying to sort of hide that context when they're exposed to the historical material. But what I find more perplexing is the second limb of your question, which is how do we tap into a more representative intellectual history in the historical context? So this has been a constant struggle for me, because in private international law, a lot of the intellectual history is Eurocentric, stems from Europe and America, and it's just heavily biased towards the metropoles. And so much of what I'm trying to do now is to try to understand how is it possible to tap into the historical context, but not hear just the voices of the private international scholars that are situated in the metropole, like Ben Atkinson Worley, who goes before the Grotius Society and says private international is the best example of human rights we have, right? We would want to understand an alternative voice. So I think there are two ways to do it in private international. One is to uncover a whole range of forgotten voices who were writing in the different parts of the empire. Not entirely representative, they were still European scholars or European judges or colonial officers, but they're being situated in the colonies sometimes offers a different perspective. Just a quick example, a year before Dicey writes his main private international volume, another private international volume that we never reference was written in India by James Rattigan, for example. And just while the Dicey's volume was being re-edited constantly in England, in a highly praiseworthy view, Bartholomew, for example, was writing a heavy critique of Dicey from Singapore. So that's one way of tapping into different contexts on the intellectual historical side. And on the more social and cultural historical aspect, I think it would be really helpful if private international law connected with the rich material of legal pluralism in the colonies that is being done by historians outside of law schools or within the law schools, but not focused on private international law per se. There's a lot of wonderful work that is being done on legal pluralism in the British Empire, not just the seminal work by Lisa Ford and Lauren Benton, but new generation of scholars that is looking at the legal pluralist context where you have the voices of the litigants themselves or the voices of the councils that were bringing these cases before court, or missionaries or advocates or whatever other figures might have had a role to play in managing the legal pluralist context of the empire. I think this should be brought into private international law. Perhaps it will take a while before it actually makes it in the teaching materials, but if at least private international as a field grappled with that parallel, we might make some inroads.
Can I just add 2 brief points? First, I agree that, particularly in private international law, when we are aiming or striving for unification or harmonization, we also must not forget the plurality that exists within this very area. So it's also important to appreciate the different voices. And secondly, I think it's also, in addition to the historical context, I think the linguistic context also plays an important role. And we say how the language of international law is portrayed, and we just discussed on how we can reframe or rephrase these kind of words around, play around and shape into different concepts like the kind of state. So it's also something that through a vigorous reimagination of these kind of language, there's also things or insights should be found in that. That's my 2 brief conclusions. Yeah.
Thank you. And thank you to all of you for your participation, for your contribution. Many thanks to all colleagues who spent their time for this webinar. Have a good day.